And we're ready, so whenever you're ready to start.
Good evening and welcome to tonight's Board of Zoning Commission meeting. My name is Scott Wagner. I am Western District Commissioner number 2. I'm joined by my colleague, Western Commissioner number 1. You are officially Commissioner John Carpenter. But that is not an official roll call, so I will reach out to Mr. Jones if you want to do a roll call.
Scott Wagner.
Here.
John Carpenter.
Here.
Joanne Lawson.
All right, we do have a majority of members here, so we'll go ahead and conduct our business, starting with the approval of minutes from December 17th, 2025, which I believe has been distributed, at least electronically, to the members. Are there any questions? And if not, then I'll look for a motion. Commissioner Carpenter.
No questions. I move that we approve the minutes from December 17, I assume 2024. That's what we're going to.
I would assume that would be correct.
So I don't know if we want to edit that on the paper, but not an important edit.
Yeah, as long as you make the motion that way.
Yeah.
Thank you.
So moved, and I will second. So it has been moved and seconded to approve the December 17th, 2024 minutes. Mr. Jones, rather, if you would call the roll.
John Carpenter.
Yes.
Scott Wagner.
Aye.
Motion carries.
All right, the minutes have been approved. Our next item of business is the election of chairperson, vice chairperson. There is only 2 of us, which will make it interesting for the third one job they get stuck with. But having said that, we'll start with the chairperson's position, and I will entertain any nominations for that position. Commissioner Carpenter.
I would like to put into nomination the name Scott Wagner.
Scott Wagner is nominated for the position. I don't hear any other nominations.
I think we need a second, though, right?
Well, I will.
Should you second yourself?
I guess I will cause my own pain and second that nomination. So it has been moved and seconded for Scott Wagner to remain as chairperson. Unless there's any further discussion, then Mr. Jones, please call the roll for that motion.
John Carpenter.
Yes.
Scott Wagner.
Aye.
Motion carries.
Thank you. So I will enjoy continuing in this position, and thank you very much for the nomination, Commissioner. We'll move on to the vice chairperson's nomination. Are there any nominations for vice chairperson?
Well, you want to nominate me?
Oh, I was going to. Who is our current vice chair?
I believe it's Commissioner Lawson.
I believe you are correct. So if you,
Or no, yeah, I'm fine with that too. So
if you like a good thing to just keep on going, I would certainly entertain that motion as well. But I will leave it to you.
yeah, I'll nominate Commissioner Lawson for the position of vice chair.
Very well, and I will second that nomination. So, seeing no further nominations, it has been moved and seconded that Commissioner Lawson will retain her vice chairpersonship. Unless there's any further discussion, Mr. Jones, if you call the roll.
John Carpenter.
Yes.
Scott Wagner.
Aye.
Motion carries.
Thank you, and we will, I'm sure, have the opportunity to communicate that on Thursday to Commissioner Lawson, and I'm sure she'll be quite happy with that result, I'm sure. All right. Thank you very much. That brings us now to our regular agenda, case number 25-101 BZA. Staff report.
Yes, Chairman, I'd like that the staff report is part of the official record. So let's see here. This case involves 3 different variances. Before we get into the specific variances, I wanted to give some background information regarding this proposal. So currently the property is roughly 40 acres. It's zoned residential ranchette or R5 and has access from W Highway. The applicant the applicants are proposing a 4-lot subdivision with each lot just short of of 10 acres. Planning and Zoning Commission approved the subdivision of land last month with the condition that they would request the variances for this. I'd also like to add, if you see that red triangle on the screen just south of Lot 1, that is a separate parcel with a different owner and is not attached to the overall property. From staff's understanding, there is a dispute over who technically owns that parcel. And the applicant may have some more details for that. And I'll get in a little bit more detail why that plays a role into these variances. So the sections of code the applicant is requesting variances from is section 151-8.4A, which deals with the width to depth ratio. Section 151-8.4G, it deals with every lot having access to a public street. And then section 151-8.2B5, that deals with the landlocked parcel, must be 20 acres and served by a 60-foot wide shared access easement. So this is the kind of a blown up picture of what we've seen with the first few slides. The variances are required for the proposal due to lot 1 not meeting that 20 acres. So with that red triangle being there, that cuts off that road frontage for this proposed lot. But the applicant is proposing a shared access, which that comes into play with the, having a 60-foot wide shared access for a 20-plus acre parcel. We allow for property to be landlocked when it goes through a subdivision phase if the property has a 60-foot wide ingress-egress easement and is 20-plus acres. So for this lot specifically, you can see that it's less. It's right under that 10-acre mark. So it does not meet that 20-acre minimum, but it does have that shared access easement. In the lot 2 as well, that deals with the width to depth ratio. So part of that triangle does cut into the amount of road frontage with that lot. So technically the width to depth for lot 2 would not meet. Also with the other variance, and it's kind of, with that red triangle there, it makes it to where lot 1 does not have that public access or access to a public street. And I also wanted to add, let's see here, the red triangle that's south of lot 1 is a factor in need for these variances, but it's important to note, even if that red triangle was part of the proposal, how lot 1 is currently laid out, that lot, no matter what, would still require a variance. Now, if that triangle was included with the property, that would remedy 2 of the variances being requested, but either way, we'd be coming in front of you guys. So with any of our variance requests, we look at our land development code variance criteria. The full criteria is attached to your guys' staff report. What's on the screen now is, are just summaries of each criteria. Each of these criteria must be met, and the burden of proof is on the applicant to show this criteria has been met. The first criteria states that requested variance arises from conditions that are unique to the property, not ordinarily found in the same zoning district, and not a result of the owner's intentional action. Granting a variance will not be contrary to public interest or adversely affect the rights of adjacent property owners. The third criteria constitutes a practical difficulty upon the property owner. And the fourth, not affect the public health, safety, or welfare, nor destroy the intent of the comprehensive plan. This is the surrounding area to kind of give you an idea of the location. Running north, maybe. So running north-south, that's C Highway, and then this is their access here off of W, and then kind of off the screen to the west more is where the location is Smithville Lake. So staff has received calls with questions regarding this, and there's also been a letter of opposition that was submitted to our office, but that had been we have already sent out the report, so I would like to attach the letter that was placed on your guys' computer as Exhibit A. And with any of our cases, we do our standard public notice requirements that include publishing in a newspaper, posting a sign on site, and sending letters to properties within a 1,500-foot radius. In this case, we sent a total of 25 letters. The applicant has provided additional information as well, which includes a letter addressing the variance criteria, and that specific letter is attached to the staff report. Staff would be happy to answer any questions the commissioners may have, and the applicant is present.
Very good. Any questions?
No, thank you.
Just one on my part, Shane, and thank you for the presentation. The letter of opposition that we have received, that was not presented previously to the Planning Commission when they met concerning this plan?
Correct.
And did they receive any communication of opposition when they met?
No. We very similar to this process, and we just received calls inquiring about it. Just curious what's
Just very
going on.
general questions about
Yeah.
it. Okay, very good. That's all I've got for you. Thank you very much. And I do understand that the applicant is here, so, and since there's really no one else in the room, I'm going to presume you are the applicant.
I am.
Then come on forward, and please, before you say anything, I believe I have to provide an oath, right? So we don't do this a lot, so I always got to review this. So if you raise your right hand, you do solemnly swear that what you are about to give this committee is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, please state your name and your relationship to the application, and then please give us your presentation.
Michelle Blankenship. My husband and I are the applicant for this. When we bought this property, we bought it a year and a half ago with the intention to split it up. And when we got on the Clay County website and everything we seen, that triangle was included. In fact, I have those printouts from Clay County that was included in our parcel. We didn't know any of that until we actually went to go split the land, and we went to the survey company, and that's when we were told that triangle didn't belong to us. Well, there was some discrepancy as who it belonged to. Initially, he thought it was the gentleman across the street. Well, then that was not the case. And then we found out it was another guy, Derek Ellis, who actually has it. And Clay County now has changed the way this map looks to add that triangle, because that wasn't on there prior to us going to the surveyor. So he has that property. We contacted him. He initially didn't know he owned it. And then he said, well, he wasn't going to sell it because he thought he would build a house on it. He called Kip and I guess was told that it was not buildable lot. So he's still kind of holding it hostage. Well, in the meantime, we talked to Zach at the survey company, and he said, why don't you call the Bennett's, who actually bought the land, because he actually owned Arling Meadows back in 2019, and that's when he acquired the triangle. So we contacted, it's a whole web, but he said, why don't you contact the Bennett's, who actually owned that property, who Derek bought it from back in 2019, and see what the intention, because what Derek did was had the Bennett's claim adverse possession of that triangle. And then he bought it from them. All this happened on the very same day. So everybody has thought that looked kind of shady. Well, Derek Ellis is actually a real estate agent who bought this land. So we contacted the Bennett's. Mr. Bennett is deceased. She's an 80-year-old woman. We got a hold of her. She's very with it, 80-year-old, very spunky 80-year-old. We asked her about, because that was the other thing, they told us there was another small triangle piece of land that maybe that's what the Bennett's were, that actually butted up to their land. And he said maybe that was the triangle that they were trying to claim adverse possession of. When we contacted her, she said she knew nothing about adverse possession. She said she never claimed adverse possession, never had any property on W Highway, and doesn't really know what this is all about. So she pulled up all her paperwork, and sure enough, she said she found that paper in there, and I have all the correspondences with her. She actually wrote a letter for us, and we had it notarized, that states she never took adverse possession. She only signed where Derek had told her to sign back in 2019. And once the property returned to the rightful owner. We've contacted the title company now. The title company is now looking into it as to, was this a fraudulent transaction and what's going on. So we still have not heard from them. And he thought maybe Derek actually tried to buy a triangle that was related to that property, but that got bought up in 1974 by the Corps of Engineers. So we're still kind of in limbo of not knowing what's going to where the triangle stands at this point.
Okay.
However, the 4 lots, we had bought that with the intention of us and our 3 kids building on the lots. MoDOT will only approve 2 driveways. So we didn't really feel like it posed a problem that not every lot had road frontage, being that the 2 lots have to share a driveway anyway. And this is all a family estate, so it's not like strangers. So that's where we're at.
Okay. Very good. Questions?
Yes, thank you for coming out this evening. Sorry about the struggles with the disputed property. I'm sure that's been a headache. Question for you and for staff both. Is it the case that but for this issue with the small red triangle on our screen, that this would be a non-issue with the driveways?
If the triangle was included in the land, there would still be the need for one variance. The variance that says lot must abut a street would go away, and the variance to allow the lot without abutting a street to be less than 20 acres would go away. We would still need the 1-to-4, exceeding the 1-to-4 width to depth ratio.
Understood. Thank you.
Anything further?
No.
Okay.
Thank you.
I think my only question just has to do with the arrangements with the kids. Certainly understand the desire to have them close. My only question is, in the event that one of the children wants to move away for whatever reason, is there an arrangement as far as what happens to that lot?
That lot will go to another family member.
Okay, so the intention is that
It's all
this
held
all
under a
stays
family
within the
estate.
Got it, gotcha. Okay, that I appreciate as well. Okay, is there, I think, unless you have any other questions?
No, I
for
think
the applicant?
perhaps Director Jones had a comment on that. I noted. So
I don't think we have any more questions of you.
Okay.
If you want to catch a seat, but Mr. Jones, if there was something else you wanted to bring to it.
Yeah, I just wanted to add that we will require, before the recording of plat, shared driveway agreements that will address the access and the maintenance of those areas. So that'll be part of the recording of the plat.
Got it. And then my question for you, Mr. Jones, is, as certainly it appears that there is some ongoing discussion to resolve the issue of that bottom triangle, if and when that gets resolved, and hopefully favorably to the applicant, what, if anything, either do you or we, and I'll use the collective we of the county, need to do to adjust if that ends positively for the applicant, or if anything, maybe not.
So yeah, we had that discussion with the applicant. So if they are able to get that triangle shaped piece, what really should happen is they should replat lots 1 and 2 and include it with those lots. Now, I suppose they could still keep it separate. We don't tell people it's a non-buildable lot. We tell them if they can provide the things that we need for a building permit and meet their setbacks, we would issue the permit. Now, the chance of doing that on that piece of ground probably isn't very high. So really, it should be included with with both of those lots, but it would require a replat, which would be just an administrative process. It wouldn't have to go to planning and zoning or county commission.
Gotcha. And on that note, I don't know if the planning commission dealt with that perspective issue at all, but I guess I guess my assumption would be, should it be favorable, should that triangle revert back to the rest of the acreage, it would be the intention to, I probably had you sit down too soon, but it would be the intention then to then do that replatting is?
Yes.
Oh, okay.
Yes.
Okay, very good, very good. Okay, anything further, Mr. Jones?
No, sir.
Very good. Then I'll bring it back here and for discussion and a motion.
Yeah, I think my comment would just be that, we have 4 criteria under the law that we have to analyze. In my view, 3 of them are pretty easily met. Surely no harm to the welfare of the community, nor does it undermine the comp plan, those sorts of things. I think the one that tends to be the hardest is, is this a unique situation or not? And I think that's an important consideration. Otherwise, what's the point of having, rules if there isn't some uniqueness involved? I'm satisfied that there is, a unique circumstance here and that the criteria are met, and therefore I would make the motion that we approve the zoning adjustment.
Very good. So it has been moved, and I will second the motion. It has been moved and seconded to move forward case number 25-101BZA with boxes marked approved. If there's no further discussion, then Mr. Jones, will you please call the roll?
John Carpenter.
Yes.
Scott Wagner.
Aye.
Motion carries.
The motion has been approved. Good luck to you.
Thank you so much.
And I'm hopeful that the issue related to, is that the Clay County Triangle, like the Bermuda Triangle? But I do hope it gets resolved favorably so you can move forward.
Yeah, thank you.
Thank you. All right, that brings us now to our other item of business on our regular agenda, which is a training session of the Clay County Board of Zoning Adjustment. And I assume, Mr. Jones, you are said trainer.
Yes, unfortunately, you're stuck with me and the assistant counselor. And I don't know if we want to have a discussion about postponing this to when all 3 members are present.
Yeah. When in speaking with Commissioner Lawson earlier, she did go out of her way to mention the possibility of requesting that. I told her I would do that. She seemed okay with regard to whatever way it went, but she did mention that.
Yeah, we can, if you have time and you want to go through this tonight, I'm happy to go through it. And we could schedule another time for her to just come in the office and go over it individually. So we're good, I think, either way, but we would like everybody to at least see the presentation.
Absolutely. I guess my question would be, do you anticipate another meeting of this body in the near future?
We do not have an application for next month, so it's hard to say, but for sure won't have one next month.
Well, I would love to leave it personally up to your discretion as to whether you want to do it now and have a separate one with Commissioner Lawson or wait till a time when we're all together. I'm good with either way if you are.
That's totally fine too.
Whatever your preference.
Then I would say let's move forward and we'll schedule a separate one with her. That way we can get any questions for you guys answered.
Well, then let's rock and roll, Mr. Jones.
Okay, so we want to we thought it'd be good since the county has gone to a first class charter county. Everything kind of for planning and zoning has changed. So I want to talk about where the authority for the BZA comes from, the types of variances that you'll see, and kind of what that case process looks like. So the authority comes from two places, comes from state statutes and then the bylaws. So the state statutes changed with the first class charter government being adopted, and our current statute is 64.120. It establishes it as 3 county commissioners as the board members. That changed from 5 citizens, 3 of which had to be unincorporated citizens. It dictates that you appoint a chair and vice chair like you did tonight. Meetings are open to the public. We file the minutes with the county clerk, and it says you may administer oaths. So you may want to ask, we'll talk about the oaths a little bit with the bylaws. The attorney may have thoughts on whether we should or shouldn't issue or do the oaths, but the state statute says you may. It does not say shall. And then it also dictates that any appeal of this body goes to the circuit court. So that's the unique thing about BZA, whereas Planning and Zoning Commission is an advisory recommendation body on everything except for the comp plan. BZA, none of your cases go to the county commission. And then the bylaws, we have two sets of bylaws in front of you today. We have the black and white copy is the existing bylaws that were last amended in 2003. And then the color copy with the new logo on it is a draft set that we would like to get approved to align it with the new state statutes. And our goal would be to have you review those between tonight's meeting and whenever we have our next meeting. If you have suggestions, changes, amendments, reach out to me. We'll make those and we'll present those as a discussion and or action item at the next meeting. And the bylaws, and feel free to interrupt me if you have questions because this is not a formal deal. Bylaws talk about the quorum. Obviously with 3 members, that's easy. We need 2 members. Talks about that we should elect the chair and vice chair at the first meeting of the year. Tells the applicant what they need to do to apply, and then gives us the order of agenda items. Now, you guys have gotten really good on those order of items. We're going to go into those in a little more detail here in a minute. And the big one I want to talk about is it does give some ethical conduct recommendations or bylaws. And the big one is it says that no board member shall have discussion of any pending agenda item other than in the public meeting. So if the applicant or opposition contacts you, you should not have those discussions until after the issue's been decided. It also says that if you have an economic or personal interest in a case, you should recuse yourself, and that the majority vote of the board can exclude a member from discussing or voting on a subject. And then let's talk about the types of variances. You're going to basically see 2 types of variances, a non-use variance and a use variance. So that table on the screen goes with a use variance, and it's out of Chapter 6 of the Land Development Code, where it lists every zoning district and then what uses are allowed in each zoning district. So if you look at cabin rentals on the screen and you go to ag zoning, it has a C. That means a conditional use permit. Then you go to the residential zonings, those cells are empty. That means cabin rental is not allowed. And then you go over to C1 and C2, and it says P, which means it's permitted by right. That means you don't have to go through any special process. You can do it as long as you do your building permit, your stormwater requirements, all that stuff. And then that 151-6.2M means there's an additional section of code on cabin rentals. So if somebody comes to staff and they're zoned R1 and they want to do cabin rentals, their options would be to rezone to one of the options that give you a conditional use permit or permitted by right, which to rezone to ag, you would need 20 acres. So let's say in this scenario, they have 12 acres and they want to do cabin rentals. They could not rezone. So their option would be to apply for a use variance. It's basically they want to use the property for a use that's not allowed by their zoning district. We don't get a whole lot of those. I think I've had 1 or 2 in my 10 years. So you won't see a whole lot of those. What you'll see more is non-use variances, which is what you saw tonight. You setback requirements, lot dimensions. You know, we had the not wanting to do the fence around the pool. So in our land development code, if they want to not meet any of those requirements, they would need a variance, and that would be a non-use variance. And then the only other type of case that you may see would be an appeal of an administrative decision. And that is where a citizen asks for the director to interpret the code. We interpret the code. They disagree with that interpretation. They can ask for a written interpretation from the director. So that's where I meet with county council. We interpret the code and put it in writing. This is how we interpret the code. And if they still disagree, they can appeal that to the Board of Zoning Adjustment. So again, I think I've had 1 of those in my time with the county. And then this is the kind of the process that the bylaws state for each case. Starts with the report from staff, then goes to questions of staff, then proponents make their presentation, opponents make their presentation, then the proponents can rebut, opponents can rebut, You can ask questions of anybody, staff, proponent, opponent, and then you ask for a motion, a second, and a vote. So I know we don't meet every month, but you've gotten really good at that, so I appreciate that. And then, so a lot kind of happens before we get here. So staff requires that the applicant schedule a pre-application meeting with staff where we go over the code, what they're required to do. We go over those 4 criteria. We are very adamant that the burden of proof is on the applicant and they should stand in front of you and go over those criteria. But you will still see that they just stand up here and just stare at you guys. So we stress that they have to present something, and it's been like pulling teeth to get them to have a good presentation. But again, if you don't feel like they've addressed those criteria, and the counselor's going to talk about those criteria, if they just stand up here and say, yeah, I have nothing to add, to me, they haven't presented their case, and it's not your job and it's not staff's job to present their case for them. And we go over that multiple times with them. Then they submit their application. That's when Shane starts doing his job. He starts doing the public notice, sending the adjoiner letters, working on the staff report, working with outside agencies if it affects outside agencies. Then we post the reports. In that time period, we're also receiving calls from neighbors, answering questions from the applicant, and then we send you the report, and then that's when we get to the BZA meeting. Not a lot, but some of these cases will come from code enforcement as well, where we get notified of something by a neighbor or our code inspector notices something that doesn't meet the code, and the only option they have is for a variance. It's either get rid of whatever the issue is or request a variance. And that's where I struggle, and the counselor will provide us more information, but that's where I struggle with, is it a result of their intentional action? And that's a very strict criteria with that process. So I think that's the basic on staff's end. Do you have questions for me?
I do, actually, and if my colleague does as well, we'll entertain those. But I couldn't help but notice in the case that we had this evening that prior to coming here, they had gone to the Planning Commission. And so I was wondering if you could review for us when and if those cases go before them, before they come here, and kind of what that interaction is.
Yeah, it's a good question. So typically we want to come here first. With the new comp plan just getting adopted, there was a mad rush of people that wanted to subdivide that possibly met the previous comp plan that wasn't going to meet the new comp plan. And we tried to allow that the best we could. So that was the case here. And with this one, we weren't totally sure that they were going to need a variance until they did the survey. So we kind of gave them the option, hey, do you want to proceed with planning and zoning or go to BZA? But typically we would do it the other way. We would come to BZA first because there's no reason for them to really have the full survey and pay for all that unless they know they're going to get the variances.
Gotcha. Thank you. Any questions?
No, thanks, appreciate the
All right.
question.
Thank you. Counselor, I think you're next, huh? Do you have pretty special effects on your presentations like Mr. Jones generally does? No.
I don't know how to do PowerPoint.
Well, very good. Well, we won't give it away, even though it's already been given away. Go for it.
So if you guys have questions, feel free to interrupt me. If you think of something afterwards, feel free to email me. We can't really discuss questions about specific cases, but certainly general questions about the BZA process, the law, that sort of thing. So the validity of the decisions that you all make are going to be impacting property owners' rights, right? And we have to ensure that the steps are followed, and we've got amazing staff that make sure that the steps are followed till we get here. And from my perspective, What's important is my ability to defend any decision you make if it ends up across the street at the courthouse, right? So what we're looking at there is the quality of the record that gets created. The job is to see if the rules should be bent, right? That's what people are here to do, is they're asking you to bend the rules for them. And private owners, they want to use their land or get permission to subdivide their land in a manner that the code otherwise prohibits. And this is a quasi-judicial process. Even though it's a may, not a shall, as far as the swearing in, I think it kind of gives it a little more of that judicial flavor if we continue to do that. The job that you have then is to interpret regulations and apply that interpretation to the particular application in front of you. Obviously, people's property is at stake, so procedural concerns are important. You all are aware of what the statutes, the ordinances, the land development code, our rules, our bylaws. But what it comes down to is fairness, reasonableness. When applicants are presenting, there's no reason to rush through the process. Certainly ask them questions to develop. It's not our job to prove their application for them, but if there are questions that will help you make your decision, feel free to ask as many questions of the applicants as of staff. Certainly if you have any legal questions, that's what I'm here for. If you review these ahead of time and you have legal questions or anticipate legal questions, feel free to reach out to me. Just don't include anybody else but Kip, me, and the individual asking the question. So as far as the due process here, the concerns with the procedure, staff make sure the citizens get their notice, get the chance to come here to be heard. They have the obligation, we have the obligation to provide the assistance with the process, but don't have the obligation to assist with proving their application. And Kip alluded to some applicants, many applicants will just make a statement rather than proving anything and providing any evidence. So just remember the burden is on those applicants. Our BZA collects the evidence, hears the testimony, finds the facts, and decides based on those facts whether to approve or deny. And you help develop a record for a possible court review. I've been doing this, 8-ish years, and I've only really had to go to court on a BZA matter once, maybe twice. It doesn't happen frequently. But what it really comes down to is, and I'll get into the standard of review of the court and how the courts have interpreted some of those standards there, the criteria. The standards are the same whether it's opposed or not. So even though we get applicants that come in like tonight that don't have anybody that really shows up to oppose it, your standards are still the same. We develop that record for the court review. If something gets appealed to the court and we have to argue it or brief it to a judge, and the record is essentially just assertions from the applicant and no real proof, that's going to be an issue. Does it happen frequently? Not really. But we need to make sure that they at least make some effort so that we can have some findings on each of the criteria. When I go through some of these cases with you, you'll see that the recurring theme is that BZA should exercise discretion to grant variances sparingly and in accordance with public welfare. So again, they're asking to bend the rules, be fair and reasonable, but don't hand it out like it's Halloween candy, right? If it goes to court, the court has the option of reversing, affirming, modifying, they can send it back to you guys to get a do-over. They can change what you've done, or they can just completely, well, they can agree with what you've done, obviously. The standard is the competent and substantial evidence upon the whole record. So essentially what happens is whoever the aggrieved party is files a petition for review with the court, and the county gets served. The court will want a copy of the record, so that's why these things are recorded. We've got to get the transcript, the staff report, any exhibits that are submitted, the opposition, then the applicant's information that they've provided. That's all going to be part of the court record that they're going to review. So one of the cases that comes up repeatedly, if you look through case law that guides BZA, is going to be, I just call it the Branham case, B-R-A-N-U-M. And it talks about the request for variances and the difference between practical difficulties and just financial impact on the applicant themselves. Not necessarily the same thing. So the conditions being unique to the subject property, not ordinarily found in the same zoning district. I think what you'll find there frequently is that, again, there's a lot of blanket assertions, but staff is probably going to be a source of information for the applicant, and that's going to come into play with respect to like the one tonight. Is this issue recurring throughout the county, or is this just a one-off kind of situation? I apologize, I just dropped my dog ear on this one here. But basically, the practical, I want to focus more on the practical difficulty because I think that comes up a lot, that people have a hard time proving. And again, there's no precise definition for that. The courts haven't said this is what to look for. They've given us some ideas of what to look for. Additional factors to consider when determining practical difficulties that you could look at are how substantial is the requested variance, whether it results in a substantial change to the character of the neighborhood, or does it create a substantial detriment to adjoining properties, whether the difficulty can be obviated by some method feasible for the applicant to pursue other than a variance, and whether, in light of the manner in which the difficulty arose and considering all relevant factors, the interests of justice will be served by granting the variance. So again, it doesn't really delve into the difficulty or the financial hardship on the owner as much as it focuses on how big of a rule are they asking you to bend, and are there other options available, for example. And I think Kip does a good job of exploring all the options, and this is sort of a last resort.
Yeah, we typically do not recommend variances. It's the last option, and probably 80% of the cases that come before you, we recommend that they not apply because we don't think they can prove that they meet the criteria.
So the board, if there is a good record made, then the board is given quite a bit of discretion. The court's not going to necessarily interfere with the decisions you make as long as there's a good record, as long as the criteria are all addressed, and you know, especially with that practical difficulty, showing that it's unusual or peculiar to the property and different somehow from other difficulties suffered throughout the rest of the zone. Any questions so far on anything?
Just one, it may seem maybe assumed, but I'll just ask it anyway. The option to go to the court, if they do not agree with this body's decision, really rests with the applicant, correct? Because they are the one that has some standing or some harm, as opposed to someone who may be a third party who may disagree with the decision of this body. My assumption is they do not have standing to then take that to court. But I'm never 100% right, as I'm reminded by my kids. And so I wanted to just go ahead and ask that question, just to make sure that I'm correct with that assumption.
So I would say that there's actually an even split from the cases that I've reviewed. If someone feels aggrieved by the decision, they have the right to file for judicial review of variances that were granted that they don't think should have been granted.
Okay. And
Then there's the flip of that where you deny a variance and the applicant thinks it should have been granted. And I would say that if you reviewing all the case law, it's pretty equal actually. The one, in fact, that I was mainly involved in, this was, I guess, almost 9 years ago now. You remember the horse hideaway, folks? So there's like the width to depth ratio, and then an outbuilding that was too close to a property line. Since it's not a pending case, I can just give you some highlights. But basically, BZA said, yeah, we're going to let you have these variances, your width to depth ratio and your the building. But it was a building that was already on the property, and the record, let's just call it kind of weak, because it just didn't get that development. You had a lot of people that actually showed up in opposition. The applicant kind of did one of those, had a real estate agent show up and just basically make assertions that it wasn't going to be adversely affecting public health, safety, or general welfare without something to back it up. And of course, you all don't exist in a vacuum, so to a certain extent, your own personal knowledge can be used in your decision as well. You know the county, you know the general nature of the county. Even if the applicant or an opponent hasn't necessarily stated something that you know, that's certainly something that you can base some of your decision on. With respect to the variances and the two different types, again, the use variance, somebody wants to use their property in a manner prohibited by zoning ordinances. Non-use is allowing the landowner to deviate from some type of a restriction. And there's not really a differentiation when it comes to the court as far as what the standard of review is going to be between the two. But again, every case you read in this area says grant them sparingly and only when exceptional circumstances are present. So I think that the focus when we have applicants come in and we ask questions, it would be appropriate to ask what practical difficulty will this have if this is not granted? And what research have they done regarding how this might impact health, safety, or welfare? The intentional action is a tricky one too, because it's frequently the reason they need these is because of something they themselves have done. And you can kind of call them out for that and say, isn't this something that you did yourself that caused the need for you to have this variance?
Well, the code's example, and we've had those come in front of us, is, those are pretty blatant examples, right? So, yeah, understood.
And do you have an example of what would be, I mean, I guess you consider tonight's not a result of their intentional action, at least for the two variances, right? Because they don't have control of that triangle piece? Or do you have other examples of what that would be, how it's not a result of their actions?
Well, if it was something that created by the condition of the land itself, perhaps topography,
Floodplain, stuff like that.
yeah. So, I mean, that's it in a nutshell. I could go through all the cases and cite them all for you if you'd like, but what it comes down to is developing the record, asking the tough questions, and applying it to these criteria. Most of them will come in and say, well, I mean, it's not contrary to public interest and won't affect the rights of adjacent property owners or residents. But when you get these variances for the driveways and so forth, tell me more about how that doesn't affect your neighbors. Tell me how this doesn't impact them potentially financially or safety-wise. I think we'll find that fewer and fewer applications should probably be granted. I know it's sometimes the difficult thing to do, especially when you don't have anybody standing here opposing. But it is a last resort. And I think that Kip does everything he can to make sure that they've explored other options, and he encourages their other options.
Yeah, and even like tonight's case, I don't want to throw them under the bus, but they purchased the property, didn't ask if they could get 4 lots out of it, came to us a year and a half later, and didn't have enough road frontage to get the 4 lots. They could have gotten 3 lots and met the county code. So we go over all those different options with them. That's what we feel our job is to give them as many options as possible. And this is the last option. And what Andy said is true. If the board's kind of wavered back and forth over the years, it gets really strict, and then I lose some members and it gets really not strict. And you notice as it gets more strict, we get less and less applications, which probably it should be closer to that side than handing them out like Halloween candy. So,
Anything else?
No, appreciate the information, and we live in a time of not especially strict adherence to the law and rules and ethical considerations, so at least we're doing our part to get these days seriously in Grant County. I think that's a good thing.
There you go. Well said. No, I think I think I'm good. I look forward to what may come from your conversation with Commissioner Lawson. If there's anything that is maybe a point that is raised based on her questions, please certainly extend that information to us. Yeah. But I certainly appreciate the presentation. It's a good reminder to understand what our job is, especially since we don't meet frequently. Mr. Jones, did you have anything else you wanted to end with?
just wanted to remind you that we don't have an application for next month, so we'll be in contact when we get another application. And we'll probably put this on the agenda next meeting, just so if something does come out of the meeting with Commissioner Lawson, that we can just have a short discussion.
Okay, very good, very good. Well, that takes us through our regular agenda. Our next item is other business. Is there anything in addition to what you just said, Mr. Jones?
No, I just handled the other business. I apologize.
Okay, no, that's quite all right. You just got to go with it. Go with it in the moment, so I have no problem with that. All right, well, if there is no other business, then we are adjourned. Thank you.
Well, I'm trying to keep you out of court. How about that?
Have you left yet?